Hello, thanks for joining me here today. I'm Bob Benjy, founder of Benjy Law Corporation, a full-service litigation law firm in Los Angeles, California, specializing in the areas of real estate, business, collections, and money judgment enforcement litigation. I'm here to talk to you today about writs of execution and how to levy them on the bank accounts of judgment debtors when one is owed money on a judgment that has not yet been paid in full. As always, please understand that this video is intended merely as educational material. It is not intended to create or establish an attorney-client relationship. So please take everything with a grain of salt and consult your own legal counsel before proceeding. Let's dive right into the materials. So after one gets a judgment, a money judgment against a judgment debtor, often there is the need to go out and affirmatively take measures to collect on that money judgment. This may include going after the bank accounts of a judgment debtor or a safe deposit box at a financial institution that may have valuables in it. How that is done is that after the judgment is entered, one will apply to the court for what's called a writ of execution. This is a 1 or 2 page document that the court will issue at the request of the judgment creditor. It will certify that a judgment has indeed been entered. It will state the dollar amounts due and owing as of a date certain. It'll identify the judgment debtor and so on and so forth, and it will include the seal of the court and will be signed by the deputy clerk of the court. It will be directed to the sheriff of a particular county. In this example, we'll use Los Angeles County Sheriff's Department. And it will basically be kind of like an authorization to the Sheriff's Department to go ahead and follow the instructions of the judgment creditor's attorney to help collect on that judgment within the confines of the dollar amounts identified on the writ and against the judgment debtor identified on the writ. Once that original writ is issued, it will be picked up or delivered to the office of the judgment creditor's attorney. He or she will then in turn direct it over to the Sheriff's Department with written instructions on what to do with it. And a file will be opened at the LA County Sheriff's Department's office, and the Sheriff's Department will then follow the instructions, so long as they comply with the statutory requirements, about how to go out and enforce this writ. Think of the writ as an order by the court to the Sheriff's Department to comply with the instructions of the judgment creditor's attorney for collection measures. Any case, once you've gone past all of that, the original writ will be kept in trust at the sheriff's office, and notices of levy will then go out to the judgment debtor, to the garnishee, which in this example will be a financial institution. We'll use Wells Fargo Bank as one example, or whatever other institution. And a memorandum of garnishee will go out to the garnishee, which again in this example is Wells Fargo Bank. All of that package will then get delivered to the financial institution in question, which again is referred to as the garnishee. The garnishee institution will then have 10 statutory days to look through their files and determine, as of the date that that writ got levied, which is a term of art really meaning served, as of the date of the levy on the financial institution, how much money that financial institution was holding in the name of the judgment debtor. And that can be an account that's exclusively in the name of a judgment debtor. It could be an account in the name of the judgment debtor's spouse, who he or she self may not even be a judgment debtor. It can be an account in the name of the judgment debtor plus some third party that's not a judgment debtor. It doesn't matter. If you cross your T's and dot your I's, any one of those can successfully be levied upon. And what will happen is the financial institution will determine, as of the date of the levy, how much money was in that account, and will freeze the account up to the dollar amount specified in that writ. Then there'll be a process by which the judgment debtor will have some time to file a claim of exemption or raise issues and objections about the levy, after which point, once those are resolved and after a certain amount of time has gone by, the financial institution must turn over that dollar amount, up to the amount specified in the writ, over to the sheriff's office. In this example, Wells Fargo would turn over the dollar amount of the writ over to the LA County Sheriff's Department, who would then in due course turn it over to the judgment creditor. The judgment creditor would take that amount, apply it to the judgment, and would then issue a partial or full satisfaction of judgment to then relieve the judgment debtor of the obligation to pay that dollar amount. And if you want to learn more about how the mathematics of that all works out, there's another video I've done that explains the interest process, interest calculations, principal calculations, etc., for how that all goes down. But that's generally how this all works. This also would apply to any safe deposit boxes that the judgment debtor may have in his or her name or in his or her spouse's name at that same financial institution. In the example of a safe deposit box, that safe deposit box would effectively get shut down and held pending further instructions, which would eventually include potentially drilling open the lock on that safe deposit box by the sheriff's department, opening the contents, taking the contents, delivering it to the sheriff's department, and allowing the sheriff's department to then go to what's called a sheriff's execution sale to sell the contents of the box to the highest bidder. Now, in that example, that box could have $50,000, $100,000 worth of diamonds in it, for example. The judgment might be worth only $10,000, and the contents of the box would get sold at an auction to the highest bidder. And if that highest bidder only bids $1,000, then that's what it would sell for, and the $1,000 would get turned over to the judgment creditor to be applied against the judgment to reduce the balance owed. Again, the judgment creditor's attorney would issue a partial or full satisfaction of judgment, which would then get filed with the court and would relieve the judgment debtor of the obligation to pay that amount. But that's generally how this all works. Please consult your own legal counsel. This is a very brief, generalized summary for how the process works, but it's pretty concise and to the point and reasonably accurate. If you have any questions, please feel free to call us. Our website is www.benjylaw, that's B-E-N-J-Y, like yellow, L-A-W.com. I'm Bob Benjy. Thank you for listening. I appreciate it.